Okay, now that you have a beginning understanding of the levels of the legal system in the federal system and in the state system, and you also have an idea of who our main players are uh, in public schools in Oklahoma, let's move into the first part of our class, and that's simply who can we require to go to school. So we're going to look at school admissions. And in this, we're going to talk a little bit about public schools versus private schools versus homeschooling, and then see some other rules that fit into this, such as marriage and immunization and compulsory attendance. And in all this, we're asking, does the state or the school, as a representative of the state, have a right to uh, put restrictions or limitations on other people's rights? Keep in mind as we go through our course, what we're doing is trying to balance out rights in a lot of positions. And so that's what we're going to see here is this balance of rights uh, in the area of school admissions. So let's begin with the first thing here, and that's simply admission to school and ages of students. So the first thing we see is that states cannot make rules that discriminate against any group. Access to education, as defined by the state, must be open to all, and it should say must there instead of is really. And this comes from the Griffin case. This is dealing as a result of the Brown versus Board of Education decision in 54 and 55. As you can see, we get a case in 64 here. And what had happened was that in Virginia, they were basically, I believe it was that they were giving vouchers to white students to attend school and excluding African American students. And so the courts came in and basically ruled that uh, this was unconstitutional. This took away the rights of the African American students. And so what we see then is that school laws are going to have to be non-discriminatory in any way that they're written so that they apply to every student. Okay. There are some other issues here talking about specifically kindergarten. Typically what we see in kindergarten laws deal with age, and September the 1st seems to be a cutoff that most, if not all, states use, as the child needs to be 5 years old by September 1st. So in general, states can limit the age of children attending school. For example, states can impose these laws that say a child has to be 5 by September 1st, or we cannot allow this child in. And for the most part, those rules are pretty well maintained. There is a little flexibility, and Alexander and Alexander discuss a case in West Virginia, which I think the child turned 5 on September 5th. And in looking at the child's maturity, the district had made an exception for that child. And so the question here, I believe, would be that if that exception was made for that child, then what about another child? And the exception was made on the maturity of this child, which apparently showed exemplary maturity for a potential 5-year-old, and that was upheld. So there is a little bit of flexibility. What we're going to see here is that while the Constitution, meaning the federal government, is going to establish some laws, or the Supreme Court is going to interpret laws based on the Constitution, states, as long as they fulfill those laws, can expand on them in their own rights. Let's talk about residency restrictions, and we see this a lot in Oklahoma. It's everywhere, really. I'm probably more familiar with it since I worked with OSSAA, the School Athletic Association, and they get lots of requests on residencies. So states may require students to reside in the said state to enroll in a state school. District leaders can also, that's pretty much an easy one. You have to live in Oklahoma if you want to attend school in Oklahoma. District leaders can also put limits and say you have to reside within the district in order to attend school here. And here's an interesting thing that the courts have acknowledged that if a child changes guardianship for the sole purpose of attending school, the district may reject that student. And I don't know if it's cliche to say we see this happening more in the area of athletics, but nonetheless, that law is out there, or that interpretation is out there, that school districts can deny a child access if they change guardianship simply for the sake of attending school. And so Alexander and Alexander talk about the terms of residence and domicile. So in most cases, these two terms are synonymous. Residence implies both the physical presence and the intention to remain. Some exceptions are considered with the best interest test. What is at the best interest of the child? And here where we see issues here coming to the forefront are when the child is not living with the custodial parents. And so what has happened here is that the courts have allowed for those exceptions where if it's in the best interest of the child, that the child live with, say, a grandparent or an extended relative such as an aunt or a cousin, and that person resides within the district, then the school can accept that as a reason for residency. Okay, so if it's the best interest of the child to do this, if they can show that it's the best interest of the child, then the school will most likely be forced to take that child as a student. So it depends on which side of this you're on, and every situation is unique. The school can say, no, your parents live 2 towns over, you're living here with your aunt and uncle, but if the child and the family can show that it's in the best interest of the child to live with the aunt and uncle, then what they're saying here is the school has to acquiesce in the best interest test, the best interest of the child. So domicile then is the true place of habitation, often used simultaneously with residence. But a person can have 2 homes. We don't see this much in Oklahoma, other than maybe divorced parents. The key here, though, is the intention of the child to remain in one place or another, and that's how we can determine residency. Another area that we see more now, I think, certainly within the last 10 years or so, is the McKinney-Vento Homeless Act. And I believe there are still funds given by the federal government for homeless children. And homeless children, the definition is pretty broad of what homeless is according to McKinney-Vento. And for example, a child who lives with his or her grandparents is considered to be homeless. Who spend a certain number of nights in a hotel or in a car, those children are considered to be homeless. So the rules change when we deal with homeless children. The main thing that we see is that if a child comes in and qualifies under the definition of homeless, according to McKinney-Vento, then the school automatically has to enroll that child pending any disputes. Okay, and it's a school of that child's choice. So if a child is homeless and wants to attend an urban school that's across town, my understanding is the district cannot restrict them and say, well, you're closer to this other school over here. You're living with your grandparents and they're closer to this school. According to the definition and the interpretation here, that child has a right to choose the school if they are indeed. And the district can investigate, but they cannot deny admittance to that child to the school of his or her choice until those investigations are concluded. So McKinney-Vento adds just a little bit of an extra layer here that schools need to be aware of. And this, of course, you may not realize, became a part of No Child Left Behind, and I believe it's still a part of ESSA. So another area of concern is, what about undocumented children? And as an administrator, I would see students and ask them. We always ask the question, do you live in the district? Where do you live? And we would find it on a map if it looked like it was close to a border. But then there's that question of undocumentation. Well, actually, the courts have ruled pretty straightforward on this, okay? State law denying children of illegal aliens the right to attend public schools when the alternative is that there is no education is unconstitutional. So in other words, you cannot deny a child the right to attend your school if they are undocumented and their parents are undocumented. The court ruled the 14th Amendment applied to all residents, regardless of legal status. Therefore, school-age children were included in the protection of those rights. The 14th Amendment, remember I said in an earlier presentation that this was probably one of the most important amendments because what we see is this tied to all the Bill of Rights in one way or another. And when cases go to the Supreme Court involving the Bill of Rights, it's usually the 14th Amendment and the First Amendment or the Fourth Amendment. Well, the biggest thing in the 14th Amendment is among other things, there's the Due Process Clause, which says you cannot have your rights taken away without due process. And so what the courts ruled in saying that this child has a right to public education is that the 14th Amendment applies to all residents within the country or within a state. And this actually goes back to a case in Texas, I believe, where a district and court in Texas said that the 14th Amendment did not apply to undocumented children. The Supreme Court said, no, that is incorrect. The court further ruled in this case of Pyler versus Doe that to deny an education, quote unquote, takes an inestimable toll on social, economic, intellectual, and psychological well-being of the individual. And therefore, the court ruled the interest of the child was more important than that of the state. And so again, what we're looking at here is that balance of rights. And here we see the court looking at what an education provides and saying that if the state felt threatened, that denying this education to the child threatened society more. And so it was weighing those rights together. Okay, threatened not just the child itself, but society in general. And then finally, we see here in 2011, the Office of Civil Rights, or OCR, clarified that district leaders may ask for birth certificates, which is not uncommon to ask for a birth certificate, but simply because a child is not born in the United States, the district cannot deny admittance for that reason alone. Also, a district cannot deny admittance of a child if a parent has the inability or refuses to show a Social Security number. So when it comes to undocumented children, as a principal, keep in mind you're going to have to enroll those children. And the courts would say that it is in the best nature for that child and ultimately society for that child to be in school and learning. So what about compulsory attendance? We, of course, have compulsory attendance laws in Oklahoma. We saw where they were pretty lax in 1907 when they were first passed. They're getting more stringent now. But first of all, the question is, are compulsory attendance laws even legal? Can a state require all its students between a certain age to attend public schools for a certain amount of time? And going back to 1922, in a Kentucky case, Strangway versus Allen, the state is the father or guardian of minors or others to the end that the health, patriotism, morality, efficiency, industry, and integrity of its citizenship may be preserved and protected. This is the doctrine of parens patriae. And I probably mispronounced that, but parens patriae. So this doctrine has been upheld through the courts, and this is the doctrine the courts use to say that a district or a state can pass compulsory attendance laws. Okay, and so we'll see redefinition of this case. But remember when I talked about there are cases, and if you think of court issues as a tree branch, there's usually a root case, and that's the trunk of the tree. And then as the court interprets different things, then you get the branches, and each of those branches represents an interpretation of what was in that. Well, this could be the trunk case for compulsory attendance. The fact that it says Kentucky and not the Supreme Court means that the case was never questioned after this to the point that it went to another level. Okay, so therefore it's considered to be the law of the land. So this doctrine, parens patriae, allows for compulsory attendance laws. Not only that, but for truancy laws to enforce those compulsory attendance laws. And the parents do not have a right to withhold their child from school. And there are some examples in the book, and one of the interesting ones was a case in Pennsylvania where parents wanted to withdraw their students from school to take them on a trip from Europe, and the school denied that, and the parents took the kids anyway. The school then gave them unexcused absences, and the parents took the case to court, and the court ruled in favor of the school, saying that the truancy laws and the compulsory attendance laws in Pennsylvania are constitutional. Now, you most likely, as a principal, at one point or another, will be presented with some type of similar situation. So use your best judgment on that. Okay. Here you have to weigh the interests of that individual student with the school and where you're going. And anyway, make your best judgment. I don't know if they were to look back on this, it would be interesting to see if the administrators involved in this particular case felt that it was worth their while to go to the courts over this issue. Of course, the text doesn't give background of the case. These kids, whether they were excessively truant or not, it doesn't say. But anyway, nonetheless, those are the kinds of things that you will decide as an administrator. The last thing here, the state or the district here must prove any absences are unexcused. The burden is not on the student to prove that they were excused. And that's a distinction there that is important to remember. There are some limits, though, on compulsory attendance. And the main thing here on this comes from a 1925 case, Pierce versus Society of Sisters. And in the rest of the chapter, Alexander and Alexander refer to the Pierce case quite a bit. This is from 1925. And the case says, the courts ruled that even though the states can pass compulsory attendance laws, the students do not have to attend public schools. Okay, and so here we see the idea of private schools brought in, meeting compulsory attendance laws, all the way back in 1925. And what the courts ruled are that the private schools had a property interest, and the parents of those children had a liberty interest in a private education, and therefore those things could not be taken away from the parents without due process, according to the 14th Amendment, and the burden was not met. And we're going to talk about what property interests and liberty interests are later on in the course, okay? But I wanted to introduce those terms to you now because they're very important terms that we will talk about specifically when we get into due process. Okay. So now that we've established that states can pass compulsory attendance laws and truancy laws, in other words, enforcing those compulsory attendance laws, what are parents' rights? Well, parents' rights in public schools, they do have some rights. Okay. The question here is, what extent do parental rights stretch concerning public education of their child or their children and others? And as the text points out, this is a fine balancing act going on, trying to weigh the rights of parents versus the rights of the state. Okay, because as we've seen in previous decisions, the courts have ruled that the states have a compelling interest to require students to attend school. So then what rights do parents have to say, I don't want my child attending a school? Or, as we'll see, I don't want my child attending that school where they teach blank. And usually what we see here are religious controversies, such as something in science or something in history. So what right do those parents have as far as that goes? So here is the case that we will examine here, Crowley versus McKinney. And what you see there at the end where it says 7th Circuit 2005, that means this case was decided in the 7th Circuit Court of Appeals in 2005. So that's the appellate jurisdiction, the second level in the federal system of courts. And it did not go to the Supreme Court. So therefore, this decision is held as it is. And so until this is challenged and changes, this is going to be the way that we see the courts interpret the law concerning parents' rights. And here the courts ruled that parents, in 3 steps here, they stated, number 1, the only constitutional right beyond that given by the state and the federal statute is the right to choose between public and private schools. So here we're saying parents have to choose between public or private schools. And we're going to bring homeschool in later on, okay? Parents do not have a constitutional right to participate in the school's management. In other words, the day-to-day running of the school, parents do not have a constitutional right to participate in the running of the school. Whether or not the parent claims that it's their tax dollars that run that school, that does not give them a right to participate in the school's management. And we'll look at curriculum in a bit. And schools have a well-grounded legal interest in limiting the presence of parents on school property. And what this decision says, what this piece of the decision says, is that schools may restrict parents from entering school property and do that legally if they can show that it's in the best interest. And I only had to do that once, and it was pretty much uncontested, but I had to limit a father from stepping foot on school ground. And if it had gone to the courts, according to Crowley and McKinney, the school, the district, we had a right to do that. Parents have no rights to the curriculum content, religious or otherwise. Okay, so even though a parent may question what the school is teaching, the parents have no right to dictate what the curriculum is. And it's understood that the curriculum is being taught through state-approved standards and using state-approved textbooks, and therefore it's really a parent versus a state issue at that point. And the courts have ruled that parents have no say-so in what the state determines to be the curriculum for the students. And later on, what we're going to see is the court's logic behind this is that parents have options. Now, whether or not all parents have the same options is questionable, and I think most would agree that all parents don't have all the same options. But parents have options if they don't want public school because of the religious belief that they hold. So that brings up the next area, and that is homeschooling. Okay, so we said earlier that uh, states can have compulsory school attendance laws, and as of 1925, the courts recognized that those compulsory attendance laws can apply to uh, public or private schools, but students still had to go to school. Now, when it comes to homeschooling, this, of course, like everything else, is a state issue. And we see considerable growth in homeschooling over the past 30 years. And where this gets into earlier what I said, the federal government's not going to get involved if the state passes a law as long as it meets federal requirements. States can pass a law that allows students to be homeschooled, and that has grown. In 1982, as you can see, there were only 2 states that allowed homeschooling. 1993, just 11 years later, more than half, 32 states allowed homeschooling. And today, all the states allow for homeschooling. And the laws are different for each state, and the reasons allowed for homeschooling children are different in each state. And it would be interesting to see where the strict laws and the loose laws are in the country versus political persuasion of the state. Looking at a correlation of voting in the last presidential election, or maybe the previous presidential election. The last was probably not the best one to judge. But it would be interesting to see, for example, in Oklahoma, it's pretty easy for parents to claim that they are going to homeschool their children. And they basically have to send a letter to the district stating that they are homeschooling their children, and that is it. Other states have passed laws that are somewhat restricting. Even though they allow homeschooling, they put limits on it. Some states have laws that say parents have to be certified teachers. They have to use the state-adopted textbooks and those kinds of things. And the courts have come in and interpreted those laws in different ways. One of the interesting things that the text does bring out is this concept of cherry picking. And again, this is up to the state to determine. And cherry picking, what we mean by that is allowing students who are homeschooled to actually enjoy the benefits of being homeschooled and the benefits of public school. So that a child in homeschool whose parents are teaching them, say their parents are not experts in a foreign language and want the child to have foreign language, they could send the child to a public school just for 1 or 2 hours to take a foreign language and then send the child back home. Again, that is up to individual states as to how they do that. And I believe that Oklahoma has laws that allow that to happen. I can't honestly say one way or the other whether it's true. I know that I'm pretty positive that Oklahoma has that involving athletics, and so I'd assume it's involving everything, not just athletics. Couple of more notes on homeschooling. Some states have laws requiring things such as certified teachers, as I was saying earlier, be used in homeschooling, or the parent at least have a college degree. Many of these have been upheld, but not all. The key is the requirements of the state encroach on religious beliefs as little as possible. So here we're weighing the state and the state's duty to provide public education versus an individual's right to freedom of religion. Okay, and so the courts take these things into deep consideration when they're making their rulings, and so that's why we see this idea of encroaching on religious beliefs as little as possible, because the courts don't want to overstep their bounds. And then finally, states can pass laws that homeschool children exhibit proficient standards on standardized testing. This, I believe, is not a rule in Oklahoma. In Massachusetts, I think it's a law, though, that your child has to participate in standardized testing, so most likely they're going to go to the local union or local school district and take state testing just like everybody else. And if they score too low, then the school can revoke their homeschool status of those students and require them to attend public schools. And the courts have upheld those kinds of decisions. Okay. So that's a little bit about homeschooling. It is allowed, all the states allow it, and it's up to the states to define how it's going to work. Some states, again, are more stringent than others in their rules, and I think Oklahoma's probably pretty lax in its rules, which as an educator from public school is a little disheartening. But aside from that, let's talk about religion. Okay. So parents have very little leeway regarding the use of religion as a reason for not attending public schools on a regular basis. And here we're talking about it's against their religion to send child to school on certain days, or it's against their religion. Again, maybe it's the curriculum. We said earlier the court said, well, the parents don't have a say-so in the curriculum. So when it comes to religion, parents really don't have a lot of options in using the public schools, using religion as a reason not to follow what the law states. Okay, the court has ruled that non-attending on Friday for religious reasons was not a valid reason. Was not valid because parents had a right to choose alternative school settings, and that's going to be the typical logic, I think. And keep in mind when I say the court with capital C, I'm talking about this is a Supreme Court case. I usually try to put the case in there. I don't know why I missed this one. This was a particular family who had religious reasons not to attend school on Friday. They were chastised or penalized by the school for absence. They took the school to court, and the court ruled that because of the options of educational settings open to the parents, again, whether or not they have access or the ability to do that is a different question. The options are out there for other ways of educating their children besides the public school, and therefore the courts ruled against parents, even though they were doing this purely on a religious reason. The one exception to this whole religion and school thing is the Yoder case, and we'll cover Yoder later on when we talk about church and state. But basically in Yoder, this was Amish children living in Wisconsin who stopped attending school about 9th grade, and the courts ruled in favor of Yoder and came up with 3 rules that were used as a result of that. And I'm going to skip a slide here. So in the Yoder case, this is 1972, the court established 3 criteria for balancing an individual's religious interests against the public interests of the state. In other words, again, it's all about a balancing act. Where does the rights of a person to have an individual religion conflict with the public interest of the state? And in Yoder, the Supreme Court came up with 3 criteria. Number 1, whether the individual's beliefs are legitimately religious and if they are sincerely held. And what they determined in the Yoder case was that the Amish were well established and this religion had been in existence for well over 200 years. So that was met. Number 2, then, the court asked whether the state regulation unduly restricts the religious practice. And in the Yoder case, it had to do with the fact that the Amish were able to show that their form of education for 16 to 18-year-old young children was equivalent or superior to that provided by the state. And they were able to do it and not lose the religiosity of their community. So the state agreed to that. And then finally, whether the state had a compelling interest justifying the regulation and whether that compelling interest is of such importance as to overcome the right to the free exercise of religion. And in the case of Yoder, they said it did not. Okay, the state of Wisconsin did not. And so that's why the court ruled in favor of Yoder. And these criteria are going to be applied later on in other cases. And for the most part, all the other cases where these criteria are applied, the plaintiffs or those seeking a religious exception are generally denied. One example your book gives was a mother who had stated that she belonged to a certain religion, and so when they went to apply the first one, beliefs are legitimately religious and if they are sincerely held, they found out that the religion was not solidified. I think that's a term I would use. The religion was not solidified enough, and therefore Yoder didn't even apply based on the first criteria. So at that point, I'm sure they stopped. A couple of more points here. States have the right to monitor private schools to the extent they fulfill the goals of education. The right does not extend to the point that states can dictate what schools teach and how they teach it. For example, private schools do not have to require certified teachers or use state-only approved textbooks. But the state does have a right, if it chooses, to monitor private schools to ensure the students are learning. And so theoretically, even though a private school is a private school not ran by the state could yank any certification and deny the private school if it were not meeting the goals of education. A couple of more interesting things here. So we've looked at compulsory attendance, we looked at truancy, we looked at private versus public schools and some homeschooling. And then now we're going to talk about two other areas where schools have rights versus the rights of individuals. The first one here is marriage, and this is an interesting one. The court has ruled that people who are married, once they become married, are no longer under the rules of compulsory education. Okay, because of the responsibilities they accept at the time they are married, the rules of compulsory education do not apply to them. So in Oklahoma, you can get married at 16 with your parents' permission. So at that point, if you wanted to, you could stop going to school. I had a particular student who, and I can't remember if she went to Texas or to Arkansas, but she actually got married at 14. Oklahoma wouldn't allow it, but one of those other states did allow it. They allowed her to get married at 14. And so once she was married, she could have chosen not to attend school. She ended up staying and finishing school. But anyway, just know that at the point a child is married, compulsory laws do not apply to that child any longer. And finally, the last slide then deals with immunizations. And we've certainly heard a lot of this in the last couple of decades. The courts are pretty straightforward on this one. States have a right to require immunization documentation before allowing students to enroll in public schools. And this goes back to a case in 1905, actually. So this case is over 100 years old, where I think it was the state of Massachusetts required people to get immunization, and it was upheld. It wasn't necessarily a school district, but the courts ruled that it was in the interest of the state, and that ruling has generally applied here. Okay, and as you can see here, this idea of immunization has been challenged on religious grounds, but to very little avail. And the same is true on philosophical grounds, when people challenge immunization on philosophical grounds. It is up to the states to issue laws that exempt students in public schools from immunizations, not immunications. So anyway, you get the idea there. So, bottom line, when it comes to school admissions, The federal government has pretty much supported the idea that school is mandatory. Uh, States can require students to attend school. Um, the exemptions that have been carved out really don't chip away at getting away from attending school. Um, Whether it's a public or a private school, uh, you're going to have to attend school in any state in which you live. And the court's going to force you to do that, or you will pay the penalty, whatever the state sets. So, hearing no questions, actually, I probably should take that out, but anyway, I thought that was pretty funny. The main thing I wanted to show you on this last slide here of the presentation is the link to Oklahoma education laws. Okay, now this is 2015 on there. So any laws that were changed last year that went into effect just in the last few months, I don't believe are listed in there, but you can get a general idea of what the laws are in Oklahoma by going to this link.